There's a case that's made a lot of headlines, especially in alternate media, about a man by the initials of CD as a result of court publication bans who has done some jail time while fighting against, or apparently trying to fight against, his daughter wanting to transition after receiving some propaganda about this in the public school system. After reading the BC Court of Appeal's decision on his contempt of court case, I realized this is a case that's an excellent example of how you can't trust alternate media much more than you can trust legacy media. You've got to look at the actual facts, because this case, especially a lot of the reports I saw, frankly, I think were just clickbait or sensationalized to make it look like something it actually wasn't. Hello, my name's Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. And I forgot to mention this in the preamble, but remember, if we get to 10,000 subscribers on YouTube, I will regrow my handlebar mustache. I gave you a preview of what that might look like in a previous episode, episode 167, where I did a live interview with Maxime Bernier. Recommend you check that out, not just for the mustache, but for the very interesting discussion we had. But today I'm talking about the case of CD. I'm going to start with a clip from alternate media. A man named Dan Dix, who has been following this case quite closely, he's been reporting on it a lot, and a number of people sent me this video of his. I'm actually going to play the whole thing. It's only about 2 minutes. Then we'll talk about how accurate that is when we look at the actual BC Court of Appeal decision.
Hi there, guys. This is Dan Dix here reporting for Press for Truth with breaking news. I just got out of the BC Supreme Court and the Court of Appeals for the final decision in a case that I've been following for almost 5 years now. And viewers of this channel are probably already well aware of the BC father whose daughter, when she was in grade 7, was shown a video by her teachers featuring a transgender character, and she started thinking, I also want to cut my hair short. I also want to identify as a boy, just like the character in that video. The teachers entertained this. They allowed her to change her name. They allowed her to change her pronouns. They suggested she go get some counseling, and the counselor suggested she go talk to a doctor. The doctor suggested she starts transitioning. All of this happened unbeknownst to this father. So obviously he's royally upset. The courts ended up saying he's not allowed to misgender his daughter. He's not allowed to use the incorrect pronouns. He can't use her so-called dead name. And he's not allowed to talk to the press about any of this. A so-called gag order was placed on this. Now, obviously, with this being insanely tyrannical, he didn't do any of these things, ended up spending 69 days in jail for that, and he was also facing a fine of upwards of $30,000. Well, today, ladies and gentlemen, the judge just decided that he has won his case. He won his appeal. No more fines, no more jail time. That's it. That's the end of it. This is such good news. This is a huge step in the right direction for justice and sanity, and it just goes to show, when you stand up like this man did against the trans activists who are taking up the BC courts and the lawyers and the judges, we can have a victory. So I just spoke with him a couple hours ago before he was supposed to turn himself into the sheriff's office, and then he had the decision was made. He's just won the thing, so he's going to be getting out any moment now. I'll do a follow-up interview to bring you this good news from the man himself. So stay tuned for that, guys. Just wanted to give you that quick update. But you can chalk one up today for the good guys.
So that video certainly makes it sound like this man was completely exonerated, his jail was canceled, he was found innocent, and it doesn't actually say that he was acquitted, but it gives the impression, talking about there's a victory for the good guys, how he's a free man. It is true that he is set free from jail, but when we look at the decision, we will see that what actually happened here is this man pled guilty to contempt of court, and that the sentence he received was quite reasonable considering the contemptuous things that he did. So here's the decision. His Majesty the King and CD 2023 BCCA 319. Link as always in the show description to the Canley version of this decision. So if we go down to the where the judgment begins, there's a bit of a summary saying that CD appeals a sentence of 6 months imprisonment for acts constituting criminal contempt, a common law offense. These acts, the violation of court orders prohibiting the publication of material that disclosed the identity of CD's child, AB, and the medical professionals treating him, I mean it's a her, but the court's calling this child him because of having been convinced by public school teachers to transition, have had consequences of a public nature, and they are still ongoing. Now this is the first important part. What was he cited for contempt for? Not for talking about this, not for expressing his opinions, but for publishing materials that disclosed the identity of AB. So the court talks about it a little bit. We heard about it from Mr. Dix, some of the background on that. Here's what the contempt was. A recurring theme throughout the proceedings has been that CD cannot or will not recognize the distinction between simply expressing his own opinions and doing so in such a way as to violate AB's privacy, even though CD has claimed that he has no wish to hurt AB. Indeed, CD appears to have gone out of his way to publicize his own and AB's identity on several platforms in Canada and the US, thus ensuring that CD would not be able to purge his contempt completely. CD has never given a satisfactory answer to the question of why he did not simply redact AB's name and personal details and his own name from his publications, interviews, and postings so that AB's privacy would be protected and court orders would not be breached. As we can see here, he could have talked about this all he wanted to. All he had to do was not talk about it in such a way that he'd be revealing his daughter's identity. Now, this is actually fairly common in court proceedings when things aren't fully determined yet, when young people are involved. In fact, any court proceeding, there's always a publication ban on young people because you don't want it coming back to haunt them later when they're adults. There's a heightened privacy for young people, which in my view is wholly appropriate. So again, all this man had to do was conduct himself in such a way that he's not revealing or essentially doxing his own child. But that's what he did. So what happened? The Crown brought a charge of criminal contempt against CD on July the 30th, 2020. CD decided to plead guilty, and the court moved immediately to the sentencing stage before Mr. Justice Tammen. So this is hardly a situation where one can say that this man was railroaded by the court, wrongfully convicted. He pled guilty. He admitted that his actions were contemptuous of the court. So what happened at the sentencing hearing is that CD sought a conditional discharge. The Crown sought a sentence of 45 days imprisonment plus probation, which the Crown described as at the low end of what would be fair. The judge had already warned counsel that he was likely to find a sentence of 45 days to be wholly inadequate, and then for reasons dated April 16th, 2021, the court sentenced CD to 6 months in prison. So CD, on the appeal, asserted that he received inadequate assistance from counsel in preparing for the sentencing and at the hearing itself. But for his counsel, Mr. Lind's failure to appreciate the benefits CD would have realized if he agreed to a plea deal offered by the Crown, CD says he would have been released on the day of sentencing, having served time in custody with credit adding up to almost 45 days. His new lawyers contend in this court that he suffered a miscarriage of justice. So you can read the decision to get more detail on this, but essentially what happened here and what he's saying happened is that his lawyer, who I note had no experience whatsoever in criminal law, and this is a family lawyer that he was having assist him with this, in my respectful opinion, that was Mr. CD's first mistake, is not hiring someone who actually knows, who's an expert in the area. I wouldn't do a family court case. I always tell my clients to go somewhere else if they have family court matters for a similar reason. I don't know anything about family law, but I am primarily a criminal defense lawyer and deal in constitutional issues, so those are within my wheelhouse. In any event, since CD apparently didn't appreciate that if it's not a joint recommendation, the judge would then have freedom to sentence however he saw fit. They didn't join the Crown attorney on the 45 days, tried getting the conditional discharge, judge totally rejected that. That's the short version. So at paragraph 74, the Court of Appeal says, in the result, I am persuaded that CD suffered substantial prejudice as a result of Mr. Lynn's failure to realize that the Crown offer was an extremely good one, and indeed such as to ensure that on pleading guilty, CD would be immediately released without a criminal record. In any event, given the foregoing, paragraph 75, it is unnecessary to consider the second ground of appeal, namely whether the sentence pronounced by the court was a fit one, because now the court is just going back to the joint recommendation, 45 days jail, and imposing that. Mr. CD has already served well more than 45 days. He had done the 45 days as the date of that sentencing, so he should have been released then. So the court doesn't go any further on that question, but they do look at the question of an order that he was ordered to pay money that he supposedly received from GoFundMe, pay that into the court. Paragraph 76 here says the third ground of appeal relates to the order that in lieu of paying a fine, CD was to pay $30,000 to the Ronald McDonald House Charities. This is a substantial amount, and I infer that it was ordered because of the evidence that CD had collected crowdfunding of over $30,000 and perhaps as much as $52,000, which the court was told had been intended to enable him to pay legal fees. CD had already incurred legal fees to his previous lawyer, and Mr. Lind told the court that he was acting pro bono. So that's a little bit of you get what you pay for, where he's not paying Mr. Lind, and then he doesn't get the most effective counsel. So the court reviewed a previous decision where the court set aside fines that had been imposed on the basis that it was inappropriate to impose substantial or any fines without first conducting an inquiry into the ability of the appellants to pay. There is no such inquiries in these cases, and similar reasoning applies in the case of CD. What little evidence there was concerning funds available to CD was vague, and there was no indication of the terms on which the crowdfunding donations were made. Were they subject to some trust, for example, or whether the funds were in fact in CD's possession? So they didn't have the evidence, so they tossed out the fine. Final disposition, allow the appeal, set aside the sentence of 6 months, and there impose the joint recommended sentence of time served, effectively 45 days. He's therefore entitled to release immediately, as the Crown had agreed, and they set aside the mandatory donation. So, yes, Mr. CD was released on the day of this decision, but as you can see, he was guilty of contempt of court. He admitted it, and he was sentenced to a jail sentence, 45 days jail. And the only reason he got the 45 days jail was because it was a joint recommendation. The decision is pretty clear that he could have and perhaps should have received significantly more. As I've pointed out, I don't think that this is an unjust decision at all. All he had to do was redact his daughter's name and probably his own. He could have talked about this all he wanted to. And again, in the end, he admitted that he was in the wrong. He pled guilty to this, so I don't think even he disagrees with me. I think it's important to actually look at the facts, look at what actually happened in the case, because if you just listen to the alternate media narrative on this, you would think it was something totally different, that this man was completely railroaded by the courts, he is thrown in jail for misgendering his daughter. That's not the case. He was put in jail for disrespecting a court order, one that was simply to protect his daughter's identity. This video, of course, is not legal advice. If you need legal advice, you can call a lawyer. You can call myself or another lawyer. My contact information is below. Please give us any recommendations of show topics you'd like to see me cover. I've received a few good ones recently, and we are working on getting to those. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media. Once again, if I get 10,000 subscribers on YouTube, I'll grow back my handlebar mustache. I've seen a lot of people posting that they're interested in seeing that, so let's make it happen.